Welcome to The Explainer. Today, we are diving into a topic that is absolutely critical for your career and, of course, for acing your ASP and CSP exams, the law. We're going to build a really clear guide to the legal principles you have to know cold. But before we get into the nitty-gritty of regulations and court cases, let's start with this big question right here. I mean, why does a document written way back in the 18th century even matter on your job site today? Well, the answer is everything. It's the absolute foundation of your legal duties as a safety pro. All right, so here's our game plan. I want you to think of this as building a legal pyramid. We're going to start with the wide, sturdy base of American law and build our way up, piece by piece, all the way to the specific liabilities that you're going to be tested on and, face in the real world. Okay, let's kick things off with Section 1. It is so important to get this. Your job goes way beyond just knowing the OSHA standards. You're navigating a really complex legal system where every decision you make or don't make can have huge consequences. Right, so this isn't just about making sure the worker in the hard hat follows the rules. It's about understanding how the judge with the gavel is going to interpret those rules. It's about really grasping the entire legal framework that shapes your responsibilities and your company's liability at the end of the day. So where does all U.S. law come from? Well, it all traces back to one single document. So for Section 2, we have to start at the very bottom of our legal pyramid, the U.S. Constitution. For your exam, you absolutely have to know what the first three articles do. It's simple, but it's crucial. Article 1, Congress makes the laws. Think the OSHA Act. Article 2, the executive branch enforces those laws. That's where an agency like OSHA gets its authority. And Article 3, the courts interpret the laws. This separation of powers, it's the whole ballgame. And here's the kicker. Article V contains what's called the Supremacy Clause. This just means that when a federal law, like an OSHA standard, bumps up against a state law, the federal law almost always wins. This is what makes a national baseline for safety standards possible in the first place. Okay, so we've got a system of laws, but where do people actually argue about them? For Section 3, we're diving into the court system, and it all boils down to one key idea: jurisdiction. A court can't just hear any case it wants to. It has to have the right jurisdiction. For your exam, you'll want to know these 4 types. Original jurisdiction is the first court that hears the case. Appellate is when a higher court reviews that decision. Exclusive means only federal courts can handle it, and concurrent means it can land in either state or federal court. Now, here's a very specific detail that is classic exam material. For a federal court to hear a case just because the people involved are from different states, that's called diversity of parties, 2 things have to be true. 1, they're from different states, and 2, the fight has to be about more than $75,000. You need both, not just one. All right, let's move on to Section 4. So, who actually writes the safety rulebook? Well, it's not just politicians in Washington. The rules you follow every single day actually come from 3 very different sources. This slide breaks it down perfectly. First up, statutory law. This is the big stuff passed by Congress, like the OSHA Act itself. Then, agencies like OSHA create administrative law. Those are the super detailed standards you live by. And finally, courts create case law through their rulings, which basically interprets how those other laws apply in real-life situations. Now, that case law we just mentioned, it runs on a really important principle called stare decisis. It's a fancy Latin term that just means let the decision stand. All it means is that courts look at past decisions, precedents, to guide how they rule on current cases. It's what makes the law consistent and predictable. And now, for Section 5, we have climbed to the very top of our legal pyramid to talk about torts. This is so important. We are talking about civil wrongs here, not crimes. This is the part of the law that deals with harm and injuries, and it's where your professional judgment will be put under a microscope more than anywhere else. Please, please, please remember these 4 elements for your exam. They're the 4 things a plaintiff, the person suing, has to prove to win their case. They have to prove every single one. If the defense can knock out just one of these elements, the whole case falls apart. Now, not all torts are created equal. They fall into 3 main buckets. You've got intentional torts, where someone meant to do the act. You have strict liability, where fault doesn't even matter. But the biggest slice of the pie, the one you'll see the most, is negligent torts. This is all about carelessness. And you have to know this term, gross negligence. This isn't a simple mistake or an oops. This is a reckless, willful disregard for safety. And here's why it's such a big deal. If an employer is found to be grossly negligent, an injured employee can sue them directly outside of the workers' compensation system. That can mean a massive increase in liability.
Then there's this idea of strict liability. This is for activities that are just inherently super dangerous. Think using explosives or keeping wild animals. In these situations, the person who got hurt doesn't have to prove you were careless. The simple fact that this ultra-hazardous thing caused them harm is enough.
Okay, last section, let's pull all of this together. How does this actually play out in your day-to-day job? And what are the key defenses and responsibilities that really define your role in managing legal risk? You will likely see this on your exam. You have to know the difference between these two defenses. In a state that uses contributory negligence, which is pretty rare now, if you're even 1% at fault for your own injury, you get $0. It's really harsh. Most states use comparative negligence, where a judge just reduces your award by how much you were at fault. Much more common. And finally, you have to understand vicarious liability. All this means is that your company can be held legally responsible for what its employees do as long as they were doing their jobs. So if your truck driver causes an accident while making a delivery, the company is on the hook for it. So let's wrap up with this thought. When you understand all this, your role completely changes, doesn't it? You're not just a safety cop preventing accidents anymore. You are a professional, actively managing your organization's legal and financial risk. And mastering these principles is what takes you from being just a technician to being an essential leader, protecting your people and your company.